Okay, so that category of consideration is the third element. So, okay, so offer is one element, acceptance is one element, so it's considered as a third element. So there's few types of consideration. Executory, meaning that it will be performed at a future date. Executed means that it has already been done, and past consideration is also considered as all done already, meaning that previously it has been made, before a promise is even made. So those are past consideration, meaning that it's not within this contract, but previously outside the context of this contract. So that is past consideration. So, and then what is considered as a valid consideration? What is a requirement for a consideration? A lot of things, you have to understand. So consideration does not need to benefit the promiser. We'll go through that, you see. So it doesn't have to be like a really fair kind of contract. It doesn't have to be equally benefit to the both party. As long as there is a consideration, it is good enough. It's a willingness between the two party to accept certain things. I mean, I can say I want to give you 100 ringgit. I mean, like, I want to say, if whoever whoever get A's, I'm gonna give you 100 ringgit. It doesn't have to be, for you may be like, I work so hard, I get an A, Dr. Ting only give me 100 ringgit. That one is not that good does not mean that, is to you is not good enough, does not mean that it is not a consideration. As long as both of you are willing to accept that particular consideration, then that is good enough. Okay. And then it is necessary, it is fundamental necessary that you must have a value. If I say to you, if I don't put a consideration here, let's say 100 ringgit, I'm giving you an offer, and you said that you accept. If there's nothing, that there's no this 100 ringgit value here, you and I are not making a contract, at all, so it is necessary, it is completely necessary to have that consideration. Even if it's 1 ringgit, is also considered as a consideration. I want to sell you this piece of land for 1 ringgit, I'll give it to you for 1 ringgit if you teach my daughter to play piano, for example. So again, it may not look fair, but then if there is, you see. The consideration need not to be adequate, it need not be beneficial, completely beneficial to the promiser. Okay, so again, the idea is it must be there. Okay, so what sort of consideration is considered as sufficient in Malaysia? So it must be valid to be sufficient. It must be reasonable, but to be adequate, it doesn't have to be adequate. It does not have to be equated. It doesn't have to be valued by a professional to see whether this is a sufficient, to see this is an adequate consideration. Okay, so it's different. All right. So just make sure that it's there. That's the thing. It cannot be absent in that sense. Situation where considerations are considered to be sufficiently provided, okay, is when a party is bound by an existing contractual duty to other, but confers the additional practical benefit to the other party. Okay, okay, this one is not so that one. Let me have a look. Seems that if the one party promised to perform an existing contractual duty to supply goods, and confer an additional benefit, an additional practical benefit. Okay, so considerate is actually, so it's like saying that supposed to be there's a consideration already, and then you add on some other benefits, so it's okay. I mean, you add on, not add on is also okay. So if the main thing is there, but then it is an additional benefit, so that is also part of the consideration as well. So even though that little part add on is not a lot, but that is also considered as part of the actual consideration. It can be bound together in that sense. Okay, so oh wait, too fast. Okay, okay, so there's a one party perform an obligation already imposed by a contract previously made with a third party. Okay, so these are saying that you are being bound by that, you see, so you still have to do it, is part of it as well. So meaning that the other contract that you have been having with another person, you know it also can be considered as to be part of this particular contract as well. Okay, so past consideration is considered as a good consideration. You can use past consideration, okay, meaning that it is not being done with this particular person, with this this A and B, part A, offeree and offeror, person A, person B, but it's being done maybe in other project, and then you brought in to this particular project. That is considered as a good consideration as well. Okay, and then love and affection, like I say, is not supposed to be a valid consideration, but in Malaysia, if it's written, if it's registered, if it's like I said, your dad says that I'm going to give you like 100,000 ringgit, or I'm going to give you 1 million tomorrow, if you're being a good boy, so that if there's no registration, if there's no it's not written down there, so that's why you will say, Daddy, please write it down, and we both sign on it, and then I'm going to go and get a lawyer to go and make a stamp on it. Then that is considered as legal. It can be considered. If you go and sue your dad, and when he doesn't do it for you, you can, because you have got it properly written down, you see. So if your husband or your wife actually tells you that, I love you so much, and I'm going to give you a huge diamond rings, tomorrow, for Christmas, or for New Year, then tomorrow and next year, he comes back, and 10 years later he still hasn't given it to you. Can you go to court and sue him? You can't, actually, because there's no element of written down, and it's not registered. Okay, so because it's actually under the natural love and affection, or a near relation to one another, so those are the things that is a bit hard to prove. Okay, it must be accord, it must be, both sides must be accepting, they must be satisfied, there must be thing, it's between the two person that contributes to that agreement, that you must, both of you must feel that it is reasonable. Okay, all right. What is this one here? Consideration need not move from the promise. Okay, I think here the English court rule that only a person who paid for a promise could sue on it. Okay, so you cannot just say that it's just basically saying that people outside the contract cannot come and sue you, because it cannot be part of, it doesn't move away from that particular contract. So if there's like a third party who is affected by you not fulfilling the promise, then you probably have to go in other directions, in other manners, such as tort, law of tort, or if there is, like, let's say the buyer and the developer, there'll probably be another contract, so you cannot go and look into the construction contract itself and to actually get a prompt to get something out of this contract, or sue, or get your compensation out of this particular contract, because the consideration need not move from the promise. Okay, so these are part and parcel of consideration, the third element. The fourth element is the intention to create that legal relation. Okay, so we'll move close up here and then move on to the next